Why you should have a durable power of attorney. A durable power of attorney may be the most important document for you to have in your estate planning arsenal. This document is specifically created under the Florida statutes to allow a person named a principal the ability to appoint one or more agents or attorneys in fact who can do certain things on behalf of the principal, mainly related to finance or legal type things where it would typically require the principal's signature or the principal's doing. This allows another person to step in and do these things. Now, why this is so important is if at any point in your life you become incapacitated, and this is why the word durable is in the durable power of attorney, it lasts through incapacitation. So if you become incapacitated and you're no longer able to do things related to your financial management or things that are very important just for your survival, right? Especially related to planning or financial type matters. The only way for someone else to be able to do these things for you if you don't have a durable power of attorney in place is for them to go through the court system and get what's called a guardianship. Now, a guardianship can be very expensive. It also requires a lot of court oversight. So we're talking about something that's costly and also very burdensome. It's burdensome on the person who has to do it. It can also be burdensome on you. Also, your rights get totally stripped in this type of an action. So by having a durable power of attorney in place, you're actually able to appoint people who you trust. So very important, these need to be people who you trust, but you're able to appoint people who can do things for you to hopefully prevent a guardianship. These are people who can do banking for you. They can open and close accounts for you. They can settle out a credit card debt for you. Things that normally only you can do. Now, it's very important. I'm going to take this a step further. It's very important that you get a durable power of attorney in place that grants broad powers. We want this because we don't want important things to be missing, that if your agent can't do them, it can be very, very problematic for you and also can lead to sometimes a very, very expensive mistake. So a lot of times, durable power of attorneys will be 11 pages long, 10 pages long, print them off the internet, maybe 5 pages long. The durable power of attorney that our office uses is a 30-page document, and it's meant to be very broad. As an example, the agent under the durable power of attorney should have the ability to make gifts and should have expanded gift powers. They should also have expanded powers when it comes to creating a trust or modifying a trust. A lot of this has to do with the fact that if you do become incapacitated and need government benefits after you're incapacitated, something like Medicaid, the agent should have the ability to apply for government benefits and public assistance on your behalf to reduce your out-of-pocket cost for long-term care and healthcare needs. There's ways that the agent can take care of all of this for you as long as the right wording is in your durable power of attorney. If it's not, then they're not able to do that. There's also ways to reduce taxes through gifting or through moving certain things around. And if you don't have the right language in your durable power of attorney, your agent is not able to do this for you. So a couple key takeaways. Obviously, you want this to be someone who you trust. I mean, they do have a lot of control, and they are going to have control over your finances. So you want to pick someone who you know is going to have your best interest in mind. However, the reason that it's so important to get this in place and to make sure that it's in place for you for life is because ultimately what we're trying to do is make the road for you much easier, also be able to protect your assets so they don't have to be spent down for things like government assistance or Medicaid, and also make it just so whatever you're used to doing day to day can be done, especially in a financial or legal capacity, can be done by another person. There's not a lot of hold up. There's not a lot of waiting. It doesn't become burdensome. It's like life can just go on and someone else can take care of these things for you. So I can't stress enough why it would be so important to have this document in place, and especially to have the right type of document in place, not a short document that doesn't give enough powers, because then what can happen is the agent's in a situation where a guardianship is still needed. So in order to sign this document, you do have to have capacity, which means you have to have the ability to understand what you're signing and know what you're signing and know who the agent is, know what you're granting, what types of powers and rights you're granting to the agent. So that's why it's also very important to get this in place before it's needed. If you get into a situation where you're incapacitated, and you're incapacitated to the point where you can't understand these things and you're unable to really give your informed consent to who the agent is or understand what they're doing, then it's too late to get it in place. And then you have to do the guardianship. So this is something that we should all consider doing once we become an adult at any age, because it is that important of a document. Okay, I hope this helps. If you have other questions about a durable power of attorney or other estate planning documents, or questions just about anything to do with probate, estate planning, inheritance at all, please contact our firm at Cause Law. If you're in Florida, contact our firm, and the link is in my bio.